Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. I am Judge Faruya. To my right here is Judge Campbell, and to my left is Judge McMurdy. And we are here for oral argument in our case number TX21-0010, Huhtamaki Inc. versus Maricopa County. Hope I said that right. And as you may know, we record and live stream these proceedings. So please give your name and also identify your client prior to your presentation. You have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require you to keep track of your own time. There are clocks in the podium for that purpose. Please understand they include any time that you want to reserve for rebuttal. And you will have to keep track of that time as well. Please keep in mind we have read the briefing, we have studied the record, we have discussed this case in conference, and with that in mind, you may proceed, counsel.
May it please the court, my name is Ben Cooper and I represent Huhtamaki Incorporated. Arizona statutes are designed to prevent a dramatic one-year jump in the tax burden on real property through at least 3 layers of protection. In this case, Maricopa County has breached each layer of protection, resulting in a 67% one-year increase in the taxable value of Huhtamaki's property. The tax court's ruling for the county contravenes the statutory language and cannot stand. The 3 layers of protection under Section 42-13302 are the 5% limit on the one-year rise under Rule A, which is the general rule. Second, the principle that Rule A continues to apply even if there's a tax parcel change, if it's the result of an action initiated by a governmental agency. And third, that even if Rule B applies, the county must use a ratio of limited cash value to full cash value that is comparable to that used for property of the same or similar use or classification. In this case, Rule A should have been applied, but even if Rule B was applied, the tax court upheld an assessment which was based on ratios which were not even remotely for properties of this comparable use or classification.
Can we start with the end, if we can, for a minute? Did you correctly assert a uniformity clause claim below?
It's not a uniformity clause claim, Your Honor, that we're asserting. It's a statutory claim. The statute itself has internal protections for its own requirements. All we did on appeal was cite a uniformity clause case to show the kind of analysis that Rule B requires by its own terms.
That didn't answer my question. Did you assert it below?
Where?
The whole
argument we're making here, yes, we did.
Okay, and where did you assert that?
I think that's set out in a reply brief. I can pull it up on what pages we made it. But we said that regardless of any constitutional argument, the statute requires use of, requires use of the ratio for comparable properties.
And did you assert examples? Did you present examples of the
Absolutely, Your Honor. We presented examples, and what the tax court acknowledged that we presented examples. But the tax court said you didn't compare it to properties that had been sold or undergone a Meyer land division. But that's irrelevant because it has to be properties. We asserted and gave examples of all the properties that we could identify without getting discovery from the county, because the county had refused to disclose the information.
Including properties that had Rule B applied to it before and thus were closer to market rate? It
doesn't matter, Your Honor, by the statute whether Rule B has been applied. The question is whether it's of a similar, same or similar use or classification. Whether Rule B has been applied does not go to use or classification of the property. That's why the tax court was trying to uphold the assessment while skipping the question of what the information that was available and whether discovery should have been provided as to comparable properties.
Do you believe that a property that has one use and classification and another property, a like property, that has the same use and classification. So they're both being used for the same purpose, okay, and they both share the same classification. One did a construction refab, okay, and so it had Rule B applied to it, and it is valued at a particular level. The other one hasn't changed in decades, and so after 2010, it's at another level. Your argument is then that the difference, the delta between those two is irrelevant?
Well, here's why. Because if you are calculating Rule B based on the ratios for other properties, regardless of whether they've not, whether they have gone to an underlying Rule B or not, that's the protection to make sure that you're not getting a large number because you had Rule B, while someone else has a much lower ratio because they haven't had Rule B. That's one of the built-in protections to make sure that Rule B doesn't produce, as in this case, a 67% increase. That is, it's another layer of protection to make sure that everyone stays in the same range. And that's because Rule B requires you to look at all those other properties with a similar use of classification, whether they've been Rule A'd or Rule B'd.
Well, but I mean, your argument is, and I don't disagree with this, because the statute says it. The argument is that the only thing that's relevant here is use and classification.
Right.
But it's use and classification in terms of what the fair market value of the property is. So we're kind of missing a key component of what the purpose of valuation is, are we not?
Your Honor, it's not about market value. It's about what are the ratios under the tax system for those comparable properties of comparable use or classification. So in this case, we believe that if the correct Rule B number were made, it would be very close to what would have been produced by Rule A. It would not have been 67%. That same use or classification is a protection to make, statutory protection to make sure that Rule B doesn't produce a dramatic increase, that the properties of a like use and classification are kept in the same range in order to prevent any kind of uniformity argument. That's a key statutory protection, but that's what was undone here. And in fact, it's undone in the worst possible way, because if you're comparing it only to other Rule B properties, then you're looking at what plug number the county was using from an undisclosed source for that ratio, rather than looking at the universe of comparable properties, regardless of whether they're Rule A or Rule B, which makes sure that we don't have untoward results. The entire statutory scheme was to prevent what happened in this case. Once you're in Rule B, you're in some kind of fair market value that Rule A properties weren't supposed to be in. Because the entire system is designed that no one is suddenly thrust into a world of unprotected market valuations where someone comes in and says, well, we think this is what it should be. Because we are valuing, the ratio of limited cash value is designed to take you away from the market-based fair cash value to begin with. And so the question is, what is that ratio?
Then what is the purpose of Rule B then?
Well,
why even have a Rule B?
The Rule B says that if we're dealing with something completely different, so that we're not just subject to the 5% increase, we're valuing something new.
Right.
Okay, a new tax parcel created by something other than a government entity. Then we have a way of adjusting the value, the taxable value, but that's not unconstrained by simply taking people outside of the protections of the statute and throwing them into some kind of new market-based valuation. That is, you still are subject to having a ratio between limited cash value and full cash value. That is the same as used by properties that haven't undergone it. So you're
I'm having a little bit of trouble understanding this argument, counsel. What you're basically saying is Rule A. If not Rule A, Rule B, which is also like Rule A.
Well, no, it's not. But it's what the design of Rule B was to say your property may go up 5%, more than 5% under Rule B. But it's still going to be checked because the ratio used in Rule B has to be, say that for same or similar properties. So you're still tethered back to a system. It may be adjusted, but the ratio means that it may go up more than 5%. But the ratio, because the full cash value may go up 5%, what you're valuing may change.
Okay, so let's move on to whether or not Rule B applies. Let's dive into that area.
The action initiated.
Right.
I think the key point here is that here the assessor, county assessor, initiated the reparcelization, the combinations and splits for its own purposes. We're not saying whether they were right or wrong, or whether they abused their discretion, or whether it was a whim. It doesn't matter. No one asked them to do it.
Counsel, is it not true that all of the property here had been reorganized as a matter of fact?
No, that's not. Well, it depends what you mean by reorganization. But the reorganization was not of tax parcels. That is, there was land that was sold, and the land incorporated portions of, I think, 4 entire tax parcels and a portion of a fifth. And required a minor land division and basically new documents that created new parcels. Is that not true? No, that's not true, Your Honor. There is no.
There isn't a minor land division that was recorded.
There is a minor land.
And that minor land division did not include new legal descriptions that described boundaries of parcels that did not heretofore exist. That's not the case.
But what the link is the next step. The property descriptions for purposes of ownership, as recorded by the county recorder, did not require new tax parcels to be drawn at all. And here's the example, because the tax statutes reflect, as we cited in our brief, the fact that you could have a transfer of ownership, a portion of a tax parcel, and the parties, so that there may be a change in the legal description for purposes of recording the new ownership. But yet, the parties remain jointly liable for the taxes on that tax parcel. That would not be necessary, that statutory provision, if simply once you did a land division in order to have different legal descriptions for purpose of ownership, you had to have new tax parcels. You don't have to have new tax parcels. In this case, the minor land division, the county disregarded the lines drawn in the minor land division because they wanted to. They decided, well...
I don't think it's because they want to. I think it's because the taxing districts are split by the Broadway Amendment.
Again, I'm not challenging
but really, I mean, when we're focusing here, the language of this exception that we're talking about, 42-13-02-4A, right? 4A.
Right.
That exception talks about initiating action. It's for when the government initiates action, is it not?
That's correct, but here it was the assessor that initiated the changes in the tax parcel.
Why did the assessor change the tax parcel? Why?
I'm sorry?
Why did the assessor change the tax
That
parcel?
is a good question, Your Honor.
Was it maybe because they had refiled under the reorganization that was approved by the city and actually recorded?
But Your Honor...
That seems like an initiation to me.
But that's not... But in that case, the counties, including Maricopa County, recognize when a taxpayer has initiated a change in the tax parcels. And there are forms for when the taxpayer wants to do that. In this case, the county could have just left the tax parcels alone. There was no need to change it. So the idea that somehow we caused it because they decided in their discretion.
So only if the taxpayer comes in and alerts the assessor to that, then that's the only way it can be an initiation.
I think that's correct, Your Honor, because that's where the change is initiated. We're not saying that, because all tax parcel changes are always carried out by the assessor. So we're not making that argument. What we're saying is that where the assessor, for its own purposes, decides that there need to be tax parcel changes, that is an action initiated by the county assessor.
I find that position somewhat at odds with what happened in Premier RV. If you recall, Premier RV was a 16-acre parcel, 1 acre of which was bare land, the rest of which had a storage facility on it. And then the owner, the prior owner of it, deeds 1 to one person, one party, and deeds the storage facility to another, and then tells no one. So they issue 2 deeds. This is what is commonly known as a split by deed.
But it's a split of the property, it wasn't a split. And in fact, the court's ruling was that was not the change in the tax parcels, that was a change in the ownership of the property. They don't connect to each other. They don't.
I don't know that I agree with that. I certainly agree with you that what Premier RV's primary holding is that that process does not complete until the assessor acts. But I don't know that there's anything in there about whether or not the state is the one that initiates it.
I don't think the issue is decided by the court one way or another. It was a timing question in Premier RV. But here, the assessor cannot force Rule B just because it decides that something's happened in the real world that it believes, rightly or wrongly, should result in a change in the tax parcel. There is no authority, a statute or otherwise, that required the assessor to have changed the tax parcels at all. And once the taxpayer exercised its discretion to make that change, that was then an action initiated by the assessor, not by the taxpayer. And let me give a perfect example. The 3 tax parcels south of the Broadway Road alignment, they were transferred as a whole.
They were transferred as a whole, but they were transferred combined as part of Lot 1.
The property was transferred as a whole, but there was no necessitation of any change in the tax parcel.
Mr. Cooper, do you agree with me that Broadway Goodyear, if it so chose, could have taken the deed for this parcel south of Broadway and transferred it to Huhtamaki, the separate deed for this parcel and transferred it to Huhtamaki, and the separate deed for this parcel and transferred it to Huhtamaki? It could have done that. Do you agree with that?
They could have done that, but
they chose not to.
But the fact that whether they chose to transfer those parcels individually or to lump them together doesn't mean that the assessor had to carry out a change in the tax.
But I think lumped together is really kind of the issue here, isn't it? I mean, it had the opportunity to transfer them and transfer them separately. And Premier RV goes through this. It says, Premier RV says, they could have elected to have transferred the property total, or they could have recorded the document, but they chose not to. But that is irrelevant to what the duty of the assessor is.
But see, Your Honor, here's where I think you moved from the manner in which the land was transferred to the duty of the assessor. There is no basis for the duty of the assessor in this factual situation to have changed any of the tax parcels.
You would agree with me that the duty of the assessor is to find property and assess its value for the purposes of taxation. That is a duty of the assessor, correct?
That is correct, and all this property was found and on the tax rolls. It was transferred. But
in the same condition?
Yes. In fact, nothing happened to the property. The fact is, it was transferred.
I don't know that I agree with that, because in one condition, you had 3 separate deeds for these properties south of Broadway alignment. And after the minor land division, you had 1 lot that combined all of his other properties. So I'm having some trouble seeing how when the assessor did its job, which is to go out and look at properties, find what property's out there and value it, and before, in one circumstance, it sees 3 new properties, speaking only to the south roadway alignment, and then afterwards sees 1 lot, which is this amalgamation of all of those, that necessarily means that it found everything in the same circumstance.
But the 3 lots south of the Broadway alignment, even by the counties taking that view, the county didn't see 3, it saw what was called Lot 1. And it decided, rather than to maintain those 3 lots separately, to create a new lot alignment based on that. That was not the lot line in the minor land division. I think the mistake, Your Honor, with all respect, is in equating the lot lines with tax parcels. Tax parcels are a completely different set of descriptions of property for purposes not of ownership or recordation, but for purposes of assessing taxes. And the change in lot lines does not translate into any need to change tax parcels. If it did, if a change in ownership, so that ownership was now split of what was 1 lot previously, then was enough to require a change in the tax parcel, there would be no need to have joint liability for taxes on a single tax partner, and the statutory provisions we have that deal with situations where you have multiple owners owning land that happens to fall within one tax parcel. We're not criticizing the county for deciding for its own purposes or administrative convenience or whatever to redraw the tax lines. We're saying that once it decides to do that, it's still under Rule A. It doesn't allow them to put it under Rule B and in order to get a higher tax burden. And even if it does, you're back in the first issue we discussed, which is it has to then be compared to all of the other properties of similar use or classification, regardless of whether they've gone through a minor land division or not, or been sold or not. That's the ultimate protection that keeps Rule B from being detached from Rule A. These were all supposed to be protections for the taxpayers. In this case, we got no protections because Rule B became its own, well, we applied the same ratio to all Rule B. Well, then there's no protection at all of ratio because you're comparing it to whatever number the county decides to use for Rule B. All the Rule Bs get shunted off to the corner. That's not what was supposed to happen. So they have a number they use for all commercial properties that are in Class 1, which could be anything from manufacturing to shopping centers to standing timber. And we're going to use that. But those are no longer tethered to all the other properties of similar use of classification, which are in Rule A. That's what that very protection was supposed to prevent. So either we're protected because it's still Rule A, or we're protected because it's Rule B tethered to the universe of properties, both Rule A and Rule B, that keeps us from getting exactly what we got in this case, a 60% rise in 1 year.
Thank you.
That's not what the legislature wanted.
Thank you, Mr. Cooper.
Thank you, Your Honor.
Mr. Branco?
Good morning, and may it please the court, my name is Joe Branco on behalf of Maricopa County Attorney Rachel Mitchell, representing defendant appellant Maricopa County. This case is about an exception in the tax code to the valuation procedure commonly called Rule B. It's found in section 42-13302A4, which simply rolls off the tongue. In relevant part, the statute creates an exception to Rule B for cases that result from an action initiated by a governmental entity. Properly understood, this language addresses a legal action initiated by government, such as a condemnation action under section 12-1116. It does not mean any administrative action by the assessor. Below, the taxpayer argued that the City of Goodyear's minor land division requirement.
Counsel?
Yes.
When we talk about your limitation on the word action, action being solely legal action, what is your best case to support that? I mean, we've talked about the word action in your briefs. We've just, where can I look and put my finger on that says it is so limited to include only legal action?
I think there are three phases to that. The first phase, as we pointed out, and admittedly for the first time on appeal pointed it out, that section 1-2151 provides as a default that action includes any matter or proceeding in a court, civil or criminal. Now that applies unless the context otherwise requires.
Well, I would suggest that the context of this statute would so require. So where do we go from there if we make that assumption?
So the phrases cases, action, and initiated are the context. We talk about initiating something. That's, I believe it's Rule 2 of the Arizona Rules of Civil Procedure that talks about initiating a civil action. Again, there's that word action. And so I think that those three things combined, cases, action, and initiated, in addition to the definitional section 1, are really strong evidence that what we're talking about here is an action like condemnation. The third component of that is what the tax court drew upon, which was saying, okay, well, if this is ambiguous, then I have an opportunity to look at legislative history. Now, I know we all poo-poo legislative history,
Yes, we do.
and that's why I don't want to rely on it. But it is clear from the legislative history that when they're talking about action in those hearings, they're talking about light rail construction in 2007.
Counsel, I'm looking at 1-215, that's where you draw your definition of action, which, just to reiterate, where you said, and you point out correctly, it says it includes any matter or proceeding in court, civil or criminal. But in that same statute, it defines includes. And it says includes or including means not limited to and is not a term of exclusion. What am I to do with that?
Isn't the better argument you have to focus on initiation or initiates?
I certainly think that initiate is one way to look at it when we're looking at the statute in context here, because as we said in our briefing, the first domino that got kicked was the 2016 minor land division, and that certainly wasn't initiated by a governmental entity. To return, Judge Furuya, sorry I tripped over your name, that's rude. I would say I'm having trouble squaring those two things because I'm not sure what type of government-initiated action we would be excluding by referring to action solely in its legal term. We've kicked this around in the office, and we've settled on the phrase the rogue assessor problem. If you had a rogue assessor who, for his own purposes, just started splitting up tax parcels around the county in order to gin up the base, I guess that would be excluded in the definition of where include is being used there, right? That's what they would. The text, I should say, the legislature has no interest in assessors going rogue and doing that, and then there being no recourse. But I guess I'm struggling to understand what, by defining action as clearly as legal action, what we would be excluding from it, that it's clear from the statute.
Well, why do we need to go down that road? It seems to me that we can simply say that it's read in its normal sense, that if a government, whether it be a legislative branch, an executive branch, or anything causes or initiates the change, that it's covered.
I think that, yeah, that's correct. This panel doesn't need to reach that issue of whether or not action is exclusive to legal action in order to uphold the tax court's decision.
What we need to focus on is what we mean by initiates. And in this case, it seems like these dominoes started to fall when the lot split was filed.
I agree. And in fact, below, it appears based on the agreements with the county's separate statement of facts that the taxpayer agreed as well. So the taxpayer did not oppose paragraph 7 of the county's separate statement of facts, which, at the risk of boring everyone, I will read a little bit of. Once a recorded plat is validated, GIS mapping proceeds with its review of the parceling of that property to assure that the assessor parcels conform to the platted legal descriptions. This involves various steps, generally summarized as follows, and in relevant part states, determine if the recorded plat changes the legal description and configuration of the real property as identified by existing parcel numbers, and if so, reflect those recorded plat changes.
Counsel, I don't think anyone questions that the assessor acted in conformity with what the assessor thought was its own internal requirements. What counsel's argument is that law does not require that. So what is your response to that? That there is absolutely no legal responsibility, no duty to change those parcels?
I think section 42-13015 would disagree with that assessment. That requires the assessor to identify by diligent inquiry and examination all real property in the county that is subject to taxation, lists the property with the determined valuation for use in the tax roll, and subpart C in particular talks about what the county assessor should be doing to make that identification and that assessment. In identifying property pursuant to this section, the assessor shall use aerial photography, applicable Department of Revenue records, building permits, and other documentary sources and technology. And that's exactly what we have here. The assessor's office ingested, sorry, I've been hanging out with data people for too long, and they talk about that a lot. It ingested the recorded 2016 minor land division, then reached out to the surveyor, obtained the CAD file, ingested that into their database, and determined that the lot lines were moved. And so in reaction to that, the assessor's reparceling process took place. That's a process, of course, that was initiated not by the assessor, but in reaction to something that a private owner did.
So anytime there's a change in recording of legal description, that's an initiation of a reassessment by the tax assessor?
That's my understanding from the record.
Okay.
Yeah, what of council's argument that this is not the change of a tax parcel? That the reorganization of all of this through the minor land division ultimately is not a tax parcel?
I think with all due respect, that it's starting to mix apples and oranges there. I mean, tax parcels are intended, right, to reflect real property in real life. And if the assessor's office is not updating those...
Well, this one does not. The subdivision is very clear on how it describes, I mean, it's a meets and bounds description, right? And that meets and bounds description is a very large piece of singular property, and the assessor's tax parcel is not.
Due to the secondary effect, I believe that's how it was referred to in the briefing and the statement of facts below, right? That's a secondary consideration after taking into account the modified lot lines because of the tax code, because of the special taxing districts. And I think also...
Does that have significance, that split? Doesn't that have significance of some kind about whether or not it was initiated?
No, because it's still...
That's clearly council's position.
I have a little trouble following council's position with all due respect, because they're saying we're not here to criticize the discretion that the assessor used and then proceeds to do exactly that. I think that the tax court on page 3 has a helpful chart that describes the relationship between the 3 lots that were at issue here, the new parcel numbers and the old parcel numbers. And in particular, we see that there's a part of the old parcel numbers in both lots 1 and 2. And I think the other thing to keep in mind, and I'm probably going to butcher this, is that there's a lot of ink spilled in the briefing about old legal descriptions, old parcels. Well, those don't describe any real property. The property in this case wasn't sold on the basis of tax parcels. It was sold on the basis of lot descriptions. And so that's what the assessor is reacting to.
So, counsel, explain this to me. We've got 42-13-302, and we've got the A and the B, and A says 5%. That way people can kind of judge how much they're going to owe in the next year. So are you saying that it bothers me that a 60% increase in tax over one calendar year occurred, and that should be limited by comparables of properties of the same or similar use or classification. They tried to get discovery on that issue, were denied discovery, but is there no protection once you get into a Rule B application for the taxpayer?
I think we've got two interests there. The first is they could have structured the land deal differently to avoid Rule B altogether. I believe that was brought up as a hypothetical earlier. I think the second part is that the record doesn't bear it out. And the reason the record doesn't bear it out is because this issue of, well, what we're really talking about is that first prefatory statement in subsection A wasn't brought in the complaint. You'll see that in the complaint there isn't any description of a uniformity clause or discrimination. Okay, set that aside. They're now saying they're not actually bringing a uniformity claim. But there also isn't any specific language that comports with Rule 8 that would have put the county on notice that what they're really talking about is Rule A. Excuse me, is the prefatory section of Rule A that you just read. Rule A, goodness. Subsection A, the prefatory statement that you said there that talks about that comparison. What we do have in the record is the ratios. What we do not have is a detailed description in there, in part because the assessor objected to some of those comparisons that the taxpayer attempted to perform in their separate statement of facts. And in reaction to this purported discovery dispute, or the county's unwillingness to provide this information because it was frankly irrelevant to the claim as pled, we didn't go through a discovery dispute mechanism. There was nothing even under Rule 56D that said, well, wait a second, I can't respond to your motion for summary judgment. So it's just too late to be bringing up and recasting these issues, even if they are troubling. I think
So
that
if we were to hypothetically talk about not this specific transaction, but a transaction in the future, what assurances would you give as the taxing authority to a purchaser of real property that they would not suffer a 60% increase in taxes under Rule B application? That's what I'm struggling with. I don't care who you are. 60% increase in tax is shocking.
it certainly is. And unfortunately, I'm not in a position right now to make any assertions or assurances about future tax rates. I can tell you based on, because part of it is it's simply not in the record. And that's what we're here to assess.
But doesn't the uniformity clause offer some protection?
It certainly does. And the taxpayer...
And that's why I asked the question earlier of counsel is, was there a uniformity clause provision or assertion that was made below that you said that they abandoned it, but did they really abandon it?
I think that they did, because the way that it wasn't raised in the complaint. The first time it was raised was in the briefing, and then the comparisons that are being done, as we objected to in response to their separate statement of fact, demonstrate that those aren't proper comparisons, and that's also what the tax court found, that there really isn't a uniformity clause issue here. I think that a future case maybe could explore the county's process for determining the ratios based on its mass appraisal process. But I don't think that we're getting there in this case by cherry picking.
Well, how would that work? So if the tax court had said, yeah, I agree with you, Assessor, that Rule B applies, and now we're going to move on to a uniformity clause assertion, and you are going to present evidence in that regard? I mean, I'm trying to think in my own mind how that would play out.
I think it could be, at the risk of giving the tax bar ideas, I think that it could play out one of two ways. I think that one way that it could have played out is exactly that. Nothing would have stopped the taxpayer from bringing a discrimination claim and saying that their property was being treated unjustly. And that's
a 67% increase. So, yeah, my property is being treated unfairly because everybody else is only going to be 5%.
Well, that's just it, though. Not everybody else is going to be only 5%. I mean, the ratio that is determined there is based on comparisons with like property. And so we have to keep in mind, these are two separate processes. Rule A is just I'm going to butcher this word too, arithmetic 5% year over year. It's what most of us as homeowners experience. When you're doing under Rule B, this isn't the only property in Maricopa County that underwent Rule B. Other properties all across the county did. And then the county, through its mass appraisal system, determines these ratios. So it's not as though this is a discrimination class of one where this property and this property owner are the only people that are experiencing tax increases above and beyond the 5%.
But what do we what do we compare? What would a trial court, what would the tax court compare? The property, all Rule B properties in the county, or all properties in the general area?
We have reached the outer limits of my knowledge of mass appraisal at the county in order to provide you sufficient assurance about
well, maybe
how
we should
ratios
maybe then we should just remand this back for the court to consider the uniformity claim.
And if they had brought this complaint and had brought a uniformity clause claim, that might be a viable option, but the tax court determined it lacked jurisdiction over the uniformity clause claim, and I think that restyling it on appeal and trying to shoehorn it into the prefatory section in subpart A is really a waste of judicial resources and judicial economy. That could have been brought in the complaint to begin with, and we would have been on a very different footing in front of you now. In fact, I might have been able to have a better answer about how the mass appraisal process works for you to provide you the sufficient assurances. But that isn't the path, talking about choices, the taxpayer took at the beginning of this litigation.
And that goes back to one of my very first questions, is was there a uniformity claim part in the complaint?
No, I don't see it. I don't see anything in there that compares. All it says is it's excessive. Keep in mind, that's exactly what we're doing when we're talking about valuation. That's what everybody claims in a valuation tax appeal, that it's excessive. You don't show up and say you haven't taxed me enough. So they can't, I don't think, bootstrap on this issue about uniformity and comparisons. The word compare isn't in there, comparison isn't in there, discrimination, uniformity clause. There's a whole discrimination section, statute that can be brought. That isn't pled here either. And so I don't think that they can bootstrap it in on appeal and claim, well, this is what we've really been coming after the whole time.
And counsel, there are time limits to bringing such claims, are there not?
Yes, there are. I believe it's 1 year after the payment of taxes.
Okay.
And the tax court addressed that in the decision as well. Unless there's anything further from the panel, I believe this court should affirm. Thank you.
Thank you, sir. Thank you for your arguments. We will take this matter under advisement and issue our decision in due course, and the court now stands in recess.